We're going to look at how contract is being formed. So basically, we're going to look at the elements of contract. Okay, so for elements of contract, there are 6 elements altogether. And then the importance of elements of contract is that contract will exist provided that any of these elements exist, and then you don't have any problem with this element. So that is what formation of contract is all about. So meaning to say that we're going to look at each and every elements of contract, because we want to identify the situations of how this element will exist in a contract. Okay, so the elements of contract consist of proposal acceptance, consideration, intention to create legal relations, certainty, capacity, and free consent. So for the purpose of this topic, we're going to look at each and every element in detail. First, we're going to look at proposal. So what is proposal? So basically, proposal is defined under Section 2, Section A of Contract Act 1950, whereby it states that proposal exists when a person signifies his willingness to do something or abstain from doing something to get assent of another. Any act of a party which shows willingness to do or not to do something is a proposal. So basically, from the definition itself, clear that proposal is actually willingness of the parties to do something or not to do something. So that is proposal. Okay. So for proposal to exist, the party must have kind of willingness to do or not to do something. So that is proposal. So for example, we can have a look at the case of Carlyle against Public Smoke Board Company. So in this situation, what happened is that Public Smoke Board advertise their product, which is called Public Smoke Board. Okay, Public Smoke Board Company introduced a new product which is called Public Smoke Board. So the purpose of this product is actually to cure influenza. And then for that purpose, Public Smoke Board advertised the product, stating that whoever used the product but still suffer from influenza will be compensated. So what happened is that Carlyle purchased the product, used it, but he still suffer from influenza. So Carlyle wanted to get the compensation from Public Smoke Board Company, but then his request was being rejected by the company. So what he did is that he sued Public Smoke Board in order to get that compensation. So in court later on, in deciding whether Carlyle should be compensated by Public Smoke Board or not, court needs to look at the contract between the two parties, between Carlyle and also Public Smoke Board Company. So in deciding the matter, first court needs to look at the elements of contract. So the elements which is relevant in this situation is the element of proposal and okay, so first look at proposal. So court needs to decide whether proposal exists or not. So under this situation, court held that advertisement made by Public Smoke Board Company is considered as a proposal. Why is it a proposal? Because it's a willingness on part of the company to compensate its customer. So that is, according to court, willingness, which is considered as proposal under the law. So under this situation, the advertisement made by Public Smoke Board Company was considered as a proposal. So that is the meaning of proposal, willingness to do something. So the willingness here refers to the act of Public Smoke Board Company to compensate its customer. So that is willingness on its part. Therefore, it's considered as a proposal. Okay, so for proposal, even though the proposal exists, proposal still needs to be communicated before it can be a valid proposal. So for proposal to be valid, it's not enough for proposal to exist, but the proposal needs to be communicated. So we have to look at communication of proposal, which is under Section 4, Section 1 of Contract 1950. So Section 4, Section 1 states that communication of proposal is complete when it comes to the knowledge of the person to whom it is made. Meaning to say that in order for the proposal to be considered as a valid proposal, the proposal needs to be communicated. Okay, so communicated here means that the proposal needs to be communicated in the sense that the other party needs to be aware of the proposal. If the other party does not aware of the proposal is said not to be communicated. Okay, the same thing, we can rely on the case of Carlyle against Public Mobile Company, whereby in this situation, proposal made by Public Mobile Company was being communicated to Clark because Clark was aware of the proposal. Why are we saying that Clark was aware of the proposal? Because Clark read the proposal before he purchased the product. So it shows that Clark was aware of the proposal. In other words, we can say that proposal has been communicated to Clark. Okay, a good example can be seen in the case of R against Clark, whereby in this case, what happened is that Clark was not aware of the reward by the government of Australia. So in the reward, the government of Australia wanted to give reward to those who gave information leading to the arrest of a criminal. So Clark gave the information while he was in prison, and then he was not aware of the reward. So in this situation, court held that Clark was not aware of the proposal, therefore proposal was not communicated to Clark, meaning to say that proposal was not exist on part of Clark because Clark was not aware of the proposal. But therefore, those people who are outside of the prison, if they read the reward, okay, and they will be considered as in awareness of the proposal, in awareness of the reward. So therefore, we can say that the reward or the proposal were communicated to them. The proposal was communicated to them. So that is for proposal and communication. Okay, so section 6, subsection A, provides for revocation of the proposal by the communication of notice of revocation by the proposal to other party. And then section 6, subsection B, by lapse of time prescribed in the proposal or lapse of reasonable time if time is not prescribed in the proposal. Section 6, subsection C, by failure of the acceptor to fulfill a condition precedent to the acceptance. And lastly, under section 6, subsection D, by the death or mental disorder of the proposer if death or mental disorder comes to the knowledge of the acceptor before acceptance. So these are the situations of how proposal can be revoked under section 6, Contract Act 1950. Okay, so the second elements that you need to know is acceptance. Okay, so for acceptance must exist after proposal exists. Then a valid contract can exist. So for acceptance, it's been defined under section 2, section B of Contract Act 1950. So basically, acceptance exists when the person to whom the proposal is made signifies his assent to the proposal is said to be accepted. So for the definition of acceptance, okay, the key word here is signifying of assent. So that is the meaning of acceptance, signifying of assent. You have to show that you are accepting. That is acceptance, showing your acceptance, signifying your assent. So according to section 7, subsection A of Contract 1950, the acceptance must be made on exactly the same term as proposed without modification or alteration. It should be absolute and unqualified. So section 7A Contract 1950 stated that when you want to accept the proposal, you have to accept it as it is. You cannot make any modification or variation to the terms of the proposal. Okay, so that is acceptance. Example of acceptance is in the case of Carlyle against Public Mobile Company. Okay, so also you can rely on the same case which we have looked at before, which is the case of Carlyle against Public Mobile Company. Under this situation, acceptance was made by Carlyle. Okay, why? Because he read the advertisement and then he purchased the product and used the product. Okay, so Carlyle is actually accepting the proposal. Okay, So that is acceptance. So for acceptance also, acceptance needs to be communicated. So for communication of acceptance is provided under section 4, subsection 2, A and B. Okay, so under section 4, subsection 2, subsection A and B, there are two ways of how acceptance can be communicated. First is acceptance through post, and then another one, acceptance through instantaneous communication. For acceptance through post, okay, so we rely on poster rule, whereby the rule is that acceptance is complete as against the proposer once the acceptor posted the letter, even though the proposer has no knowledge of the acceptance. Okay, so the poster rule further stated that when the letter is posted, the acceptor has put it in the course of transmission and he no longer has control over the letter. Thus, the transaction is binding irrespective of delay or disappearance in the course of transmission. Okay, so this can be seen in the case of Ignatius against Bell, whereby in this situation, the acceptance was made by post and then there was a delay in the transmission of the letter. But still, court held that acceptance was communicated, therefore a valid contract exists between the parties. Yet another way of how acceptance can come to existence is through instantaneous communication. Okay, so under instantaneous communication is a method of communicating such as telephone, answering machine, email, SMS, and WhatsApp. Okay, so under this situation, if the acceptor is using telephone, he must make sure that he talks to the proposer. If he's using answering machine, proposer has to listen to the message. If he's using email, SMS, or WhatsApp, the proposer must have read the message. So for example, in the case of Antares Limited against Miles Far East Corporation, so in this case, court held that if the parties is using instantaneous communication, okay, the communication of acceptance is complete once the other party is aware of the acceptance. So that is two ways of how acceptance can be communicated. Okay, lastly, on the topic of revocation of acceptance, we need to look at revocation of acceptance. Okay, so this is the last area that we need to look at under the topic of acceptance. Okay, so for revocation of acceptance, revocation means you want to end the acceptance, you want to terminate the acceptance. So for revocation of acceptance is under section 5, subsection 2 of Contract 1950, okay, which provides that acceptance may be revoked at any time before the communication of acceptance is complete as against the acceptor, but not afterward. Section 4, subsection 3, the communication of revocation is complete as against the person who makes it when it is communicated to other person, and person who receive it when it comes to his knowledge. So basically, for revocation of acceptance, you can revoke the acceptance before the communication of acceptance is completed. Meaning to say that if you are accepting through post, you can revoke before the letter is posted. And then if you are accepting through instantaneous communication, you can revoke the acceptance before the proposer is aware of the acceptance. So that is how acceptance can be revoked. Okay, so the second element of contract is consideration. So consideration is under section 2, subsection D, Contract 1950. So this is supposed to be D, not B. Okay. So according to section 2D Contract 1950, it states that consideration exists when the promisee has do or promised to do something or abstain from doing something at the desire of the promisor. So consideration can be considered as a bargain, the price of which one party pays to buy the promise of act of the other. And consideration must move from both sides, from the promisor to the promisee, and from the promisee to the promisor. So that is consideration. Consideration is actually a bargain between two parties. The price of which the other party pays to buy the promise or act of the other. So meaning to say that basically consideration is about promise. Okay, one party makes promise to the other party, and then the other party can either promise do an act or has done an act on part of the promisor. Therefore, consideration exists between the party. So for consideration, there are three types of consideration that you need to know. So the first one is executory consideration, the second one is executed consideration, and then the last one is past consideration. So these are the three types of consideration that you need to know. Okay, so the first one is executory consideration. So for executory consideration, it's a promise in return of a promise, or we call it promise for a promise. Okay, meaning to say that one party makes a promise, the other party makes another promise. Okay, so it's a promise for a promise. Okay, you can have a look at the case of K. Murugisi against Nadaraja, whereby in this case involve two parties, K. Murugisu and Nadaraja. Both party makes promises. Okay, one party promised to pay, another party promised to buy. Okay, so court held that consideration exists between the two parties. Therefore, a valid contract exists. Once a valid contract exists between the parties, both parties needs to perform their part of the contract. So if they do not perform their part of the contract, therefore they are said in breach of the contract. If one party breach the contract, the other party or the injured party will have the right to sue. Okay. And then the second one is executed consideration. So executed consideration is a promise made in return for the performance of an act, or we call it promise for an act. One party makes a promise, the other party do an act. So that is executed consideration, promise for an act. For example, in the case of Osman bin Abdul Ghani and others against United Asian Bank Berhad. Okay, so in this case, United Asian Bank Berhad promised not to sue Osman if Osman pay his debt. Okay, so Osman pay his debt, but somehow United Asian Bank Berhad sue Osman. So under this situation, court held that executed consideration exists, therefore a valid contract exists between Osman and the bank. But since the bank sued Osman, therefore the bank was considered as in breach of the contract. Therefore, Osman therefore can take action against the bank. That is executed consideration. And lastly, past consideration. So for past consideration, it's a promise to do something in return for an act which has already been performed. Meaning to say that you promise today, but then the act has already been done in the past. For example, you promise your friend today, but then the act that your friend actually has done the act in the past. So that is past consideration. For example, in the case of Kapung Prospecting Limited and SK Jakartasan and others, again A is Smish and Majori Smish. So in this case, what happened is that Kapung Prospecting Limited, this is actually an appeal case. So what happened is that Kapung Prospecting promised to pay Smish a certain amount of money for the work which has been done by Smish in the past. So court held that it becomes a past consideration. So since Kapung did not pay Smish as promised, therefore Smish has the right to sue Kapung. Okay. Next is the third element of contract, which is intention to create legal relation. So for intention to create legal relation, in order for a valid contract to exist, parties to the contract must have the intention to create legal relation. Intention, but then the problem with intention is that we don't know the intention of parties. Okay, we don't know the intention of parties. Since we don't know the intention of parties, therefore, okay, the law makes presumption as to the intention of parties. Okay, the law presumes the intention of parties. Okay, so the basically it's based on presumption. Okay, so law requires that for an agreement to be legally enforceable, the party should have an intention either expressed or implied from the circumstances. There are two situations whereby intention of parties is of great importance: for business agreement and social, domestic, and family agreement. Okay, so for business agreement, the presumption is that parties have an intention to create legal relation. In business agreement, the law presumes that the parties have the intention to create legal relation. Since the presumption has been established, therefore it's up to the parties to challenge it. So that is for business agreement. So for business agreement, the law presumes that the parties have the intention to create legal relation. Meaning to say that once the parties entered in a contract for business purposes, automatically a valid contract exists between them. So that is being explained in the case of Diamond Developments and Berhad against Matthew Louis Chintek and another, 1981. So under that, in that case, the parties were actually in business agreement. So court held that both parties have the intention to create legal relation. Okay, the second situation would be social, domestic, and family agreement. So for social, domestic, and family agreement, the presumption is that parties have no intention to create legal relation. Since parties have no intention to create legal relation, therefore, no contract exists between parties. Here you can have a look at the case of Balfour against Balfour. Okay, so in this case, it's about agreement between husband and wife. Okay, the agreement was actually to pay allowance to the wife. So court held that parties have no intention to create legal relation because it involved family agreement. Okay, therefore, no contract exists between them. Therefore, the parties have no right to sue and be sued. But then, for social, domestic, and family agreement, there is a rebuttable presumption whereby in the case of married and married, it involves agreement between husband and wife. But then the agreement is for property. Okay, therefore court held that the agreement was a valid agreement. The contract was a valid contract because even though it involved husband and wife, but the contract is actually for property. Therefore, a valid contract exists between them. So that's why it falls under rebuttable presumption. Okay, the fourth element of contract is certainty. Certainty comes from the word certain. So meaning to say that for a valid contract to exist, the terms of the contract must be certain. Terms of the contract must be certain. Meaning to say that both parties must be aware of the terms of the contract and then they have to understand the terms of the contract clearly. So that is certainty lah. The terms of the contract must be certain. Section 30, Contract Act 1950 provides that agreement, the meaning of which is not certain or capable of being made certain, are void. Okay, for example, in the case of Karupanchayati against Swahtian. So in this case, what happened is that okay, the terms of the contract was not certain. Okay, because the party did not state clearly the period for the lease. Okay, because the period of the lease is for as long as you like. So the term as long as you like was considered as not certain by the court. So therefore, the contract was not valid. That is what happened in the case of Karupanchayati against Swahtian. So supposedly, the terms of the contract must stated clearly the period for the contract. Okay, the parties cannot simply state as long as you like. So the word as long as you like is considered as uncertain. Therefore, contract should not be a valid contract. So that is for certainty. Okay, next is capacity. So capacity is the fifth element of contract. Okay, so for capacity, basically it refers to capability of a person to enter into a contract or competency of parties to enter into a contract. Okay, so competency of parties, whether a party is competent or not, is based on age and also state of mind. Okay, there are certain age period for a person to be competent to enter into a contract. So Section 11, Contract 1950 provides that every person who has reached the age of majority according to the law which he is subject and who is sound mind and not disqualified from contracting by any law is competent to contract. So that is competency of parties. According to Section 7, according to Section 11, person is said to be competent if he has reached the age of majority, if he is of sound mind, and also is not being disqualified from contracting by any law. Therefore, that person is considered as competent to contract or competent to enter into a contract. So, according to Section 11, there are 3 elements which affects the competency of parties to enter into a contract. So, the elements are age, state of mind, and disqualification by law. But then for the purpose of capacity ni, we're just gonna look at the 2 elements which are age and state of mind. Okay, so age. So age is one of the elements which is important to decide whether a person is capable to enter into a contract or not, whether a person is competent or not to enter into a contract. Okay, so for age required under the law is age of majority. So according to Section 2 of Age of Majority Act 1971, the age of majority is 18 and above. The person is called a major. So those who is below 18 years old is a minor. So the general is that all contracts entered into by minors are void. Reason for this is to prevent the minors against any consequences of his own action. Okay, so that is the general lah. Dia kata all contracts entered into by minors are void. But then this general is open to exception. Okay, so for the general, we can have a look at the case of Tan Hee Juan against D. Bonikiat. Okay, so in this case, it involves contract between a major and a minor. So court held that the contract should be void because one of the parties was a minor. Okay, but then, as I mentioned just now, the general is open to exception. Okay, so the exception is if the contract involves contract for necessities, the contract can be a valid contract. So the question now is what is considered as necessities. So necessities are minor's actual needs and his station in life. For example, clothes, food, education, shelter, transport. So those are considered as necessities. So for contract of necessities, according to Section 69 of Contract 1950, the contract is a valid contract provided that the 3 situation is being fulfilled. Okay, the 3 conditions are being fulfilled. So the condition number 1, the necessity must have been supplied to a minor. Agreement to supply is void. Condition number 2, the minor's liability includes necessity supplied to anyone whom he is legally bound to support, such as a wife or child. And then condition number 3, the supplier of necessity may claim only a reasonable price which may not be the same as the contract price. Condition number 4, minor will only pay if he has the property to do so. Okay, so according to Section 69, contract with a minor is a valid contract provided that all these 4 conditions are fulfilled. Example, in the case of Nash against Inman and the case of Government of Malaysia against Gujarat Singh and others. In the case of Nash against Inman, in this case, the clothes ordered by the minor was not considered as necessities because the minor has a lot of clothes already. So court held that it doesn't constitute necessities. Therefore, the contract was not a valid contract. Whereas in the case of Government of Malaysia against Gujarat Singh and others, in this situation, a minor entered into a contract with Government of Malaysia to get sponsorship for his study. Okay, so therefore, court held that the contract was a valid contract because education is considered as necessities. The contract is a valid contract. Okay, And also we need to look at state of mind. For a contract to be valid, the parties who enter into contract must be sound mind. Okay, so it's according to section 12, section 1, a person who is competent to enter into contract is a person who is of sound mind. The person, sound mind means the person must be capable of understanding the contract and form a rational judgment upon its effect. Okay, so that is the meaning of sound mind. Must understand the contract and can form a rational judgment upon its effect. Section 12, Section 2, a person who usually suffers from mental disorder may make a contract during those periods when he is sound. Okay, for a mentally disordered person, okay, this person can still enter into a valid contract provided that when he signed the contract, he is mentally stable. Okay, and then Section 12, Section 3, a person who is usually of sound mind but occasionally of unsound mind may not make a contract when he is of unsound mind. So this refers to person who usually sound mind but occasionally unsound mind, refers to person who is drunk, sick or under influence of drug. For this particular person, they can have a valid contract provided that when they enter into a contract at that particular moment, he was of sound mind. Okay. So effect of contract. So if contract entered into by person who is of unsound mind, what happened to the contract? So basically the Malaysian law is silent on the effect of the contract. However, the English law treated the contract as voidable. Okay, and then the last element of contract is consent of parties. So for consent of parties, basically to have a valid contract, the parties must have consented to the contract. Okay, all the parties must have consented to the contract. But then if one of the parties is not consenting to the contract, therefore a valid contract cannot exist. So for consent of parties, we have to look at section 10, section 1 of Contract 1950, which provides that all agreements are contract if they are made by the free consent of parties competent to contract. Okay, so for a contract to be valid, parties must have freely consented to the contract. Freely consented. Okay. So section 13, Contract 1950 provides that two or more persons are said to consent when they agree upon the same thing in the same sense. So that is the meaning of consent. Consent means when two or more persons are said to consent when they agreed upon the same thing in the same sense. Agreed upon the same thing in the same sense. So that is consent. What about free consent? What is the meaning of free consent? So free consent has been defined in the section 14 of Contract 1950, which provides that consent is said to be free if it's not caused by coercion, undue influence, fraud, misrepresentation, and mistakes. So if any of these elements exist in the contract, okay, so we say that the parties, one of the parties to the contract does not freely consented to the contract. The existence of any of these elements, coercion, and influence, fraud, misrepresentation, or mistakes, will impede the validity of the contract. Okay, so we need to say that you cannot have any of these elements in the contract. If you have any of these elements in the contract will not be a valid contract. So what? Okay, so in the case of Kesamal, son of Leishman Das against Valiapa, it involved an agreement to transfer a piece of land by the Sultan in the presence of a Japanese soldier. So court held that under that situation, coercion exists because when making the decision, the Sultan was being influenced by the existence of the Japanese soldier. So what happened to the contract if coercion exists? So basically the contract becomes voidable. Next is undue influence. So undue influence is defined under section 16 Contract 1950, which covers domination of will by one party over the other and obtain an unfair advantage. So this is undue influence is a situation whereby it involves two parties, one party is with the power, the other party is without power, the one who is with power takes advantage over the other who is without power. So that is undue influence. Okay, for example, between lawyer and client, between doctors and patient. Okay, so those are situations of undue influence whereby the one who is with power takes advantage over the other who is without power. So that is what happened in the case of Chaik Singh against Budin bin Abdullah. Okay, so in this case, the case of Chaik Singh against Budin bin Abdullah, what happened is that okay, so defendant was an illiterate person. Okay, so Chaik Singh lent money to Budin bin Abdullah, and then in the agreement, in the contract, it was stated that the interest was charged at 36%. Okay, that was excessive. Therefore, the contract should not be a valid contract according to the court, because under this situation, Budin bin Abdullah was an illiterate person. Since he was an illiterate person, and then he was not able to read the contract, therefore court held that undue influence exists there. So what happened to the contract if undue influence exists? The contract should be voidable. Okay, next is fraud. Fraud is under section 17, which provides that fraud are various acts committed by parties to a contract with intent to deceive the other contracting party. Okay, so fraud is actually deceiving the other party. Deceive comes from the word deceive. For example, in the case of Lakshmi Arumugam against Anamali, so in the case of Lakshmi Arumugam against Anamali, what happened is that the party was being defrauded. Okay, the party was asked to sign a document for a loan, but actually document was for transfer. So court held that fraud exists there. Therefore, the contract should be voidable. Then next is misrepresentation. Misrepresentation comes from the word mis and representation, meaning to say that it's a false statement made by a representative and which induce the other party to enter into a contract. Okay, meaning to say that misrepresentation, meaning you are making a representation which is not true, and then because of your representation, it induced the other party to enter into a contract. So that is misrepresentation. The same thing happens for misrepresentation, whereby the court held that the contract should be voidable. Okay, believing that the document is to witness his brother's signature, but actually the document is not for that purpose. Okay, so he argued that if he knew that the document for other purposes, apart from witnessing his brother's signature, he wouldn't sign the agreement. So under this situation, the party plea not as factored in court, so court held that the contract should be void. Okay. Content of contract. So for content of contract, it refers to terms of the contract. So there are two types of term. First one is express term. The second one is implied terms. So by the word express, it refers to terms which are orally agreed, or terms which are agreed in writing. Okay, meaning to say that for express term are terms that are agreed upon orally or in writing, meaning that to say that both parties agree to the terms of the contract. Okay, and then express terms are binding on both employer and employee. The terms cannot be changed. Changes can only be made by mutual consent of both parties. Example of express terms are job title, wages, other benefits, working hours, holiday and leave entitlement, and mobility. Those are examples of express terms. Whereas for implied terms are terms which are presumed from the contract. Okay, so the terms are based on presumption. Okay, so the implied terms are binding on employer and employee. The example of implied terms: employee must be obedient. Employee must act honestly. Okay, employee must take care when carrying out his job. Employer must pay employee wages. Employer must provide a safe working environment. Employer must respect and trust the employee. So these are called implied terms. Okay, so sometimes it's not being included in written in the contract. It's not in writing, so it's just being presumed from the contract. So once you become an employee, you know that impliedly you have to come to work on time, you have to go back on time. Okay, you need to do your work properly. So those are considered as implied terms in a contract. Next is discharge of contract. So what is the meaning of discharge? Discharge meaning you want to end the contract. Okay, discharge of contract. So a contract entered into by a sports person can be discharged. Discharge means contract is terminated. You want to terminate the contract. It involves a situation whereby the parties to the contract is no longer obliged to perform the contract. So there are 4 situations whereby the contract can be discharged. Okay, so the 4 situations are by performance, by consent, by impossibility, or by breach. Okay, so that's how contract can be discharged. First one is by performance. The by performance meaning you perform your part of the contract. Once you perform your part of the contract, if both parties perform their part of the contract is said to be discharged by performance. Okay, for example, you are selling your car to Abu. Okay, and Abu agrees to buy your car. So under that situation, both parties has your own obligation. On part of you have to transfer the car to Abu, and on part of Abu is supposed to pay for the price of the car. So those are your obligation and Abu's obligation under the contract. So in order to discharge the contract, both parties, you and Abu, needs to do your part of the contract. On your part, you have to transfer the car to Abu. On Abu's part, Abu has to pay for the price of the car. If both parties has performed their part of the contract, then the contract is said to be discharged. So once the contract is discharged, parties have no right to sue and be sued. So that is discharged by performance. Both parties have to carry out their obligation. It means that the contract must be strictly performed in accordance with the terms of the contract unless the parties have agreed otherwise. Promisor must be prepared to perform his obligation at the time and place at which he has undertaken to do it. That is discharge by performance. Second, discharge by consent. Consent means both parties agree that the contract should be discharged. So the general rule is that contract that is created by consent can be extinguished by consent either express or implied. The consent of all parties to the contract is necessary to discharge the contract. Okay, for example, we refer to your situation just now whereby you entered the contract to sell your car to Abu. So suddenly you change your mind. Okay, you don't want to sell your car to Abu. Okay, so under this situation, the contract can be discharged by consent provided that Abu agrees to it. You said to Abu that you don't want to sell the car to Abu, and then suddenly Abu said, okay, never mind. Okay, we'll just forget about it. So that is a situation of how contract can be discharged by consent. Next is discharge by impossibility of performance. So this is a situation whereby it is impossible for the contract to be performed. It's provided under Section 51 of Contract 1950, which provides that 2 situations of impossibility of performance: impossibility of performance at the time a contract is made, and impossibility after it has been made. So if this performance has become impossible, therefore the contract should be discharged. Okay, for example, in the case of Taylor against Cadwell. So in the case of Taylor against Cadwell, what happened is that a music hall hired by the defendant from the plaintiff for a series of concerts was burned down before the date of the concert. So court held that the contract was discharged due to frustration. Okay, due to impossibility of performance lah. Meaning to say that impossible to perform the contract because the the hall has been burned down. Okay, and lastly, discharge by breach. So for discharge by breach, this is a situation whereby one party breached the contract, and when one party breached the contract, and then the other party sue, and then the one who is in breach, okay, pay for damages, automatically the contract is said to be discharged. When a promisor fails to perform his obligation or to tender performance, there is a breach of contract. Such breach entitles the party to repudiate or continue with the contract and claim damages. Okay, next is breach of contract and remedies. So what is breach of contract? So breach of contract is a situation whereby one party fails to fulfill his promise in the contract. When breach of contract occurs, the dispute can be brought to court for resolution. In court, the innocent party can seek remedies. Okay, so that is breach of contract lah. Breach of contract occurs when one party does not perform his part of the contract. If breach occurs, therefore, the innocent party can seek remedies. So, under law of contract, there are 5 remedies that you need to know. So for remedies for breach of contract available for the party not in default to claim. If a contract entered by a sportsperson is in breach, the party involved can seek remedies. So the remedies available are rescission, damages, passive performance, injunction, and quantum merit. Okay, so rescission. What is a rescission? Rescission is the contract is put to an end. The parties to the contract are no longer obliged to perform the contract. If the party choose to rescind the contract, the party who has received any benefit under the contract is bound to restore it to the person from whom he received it. Damages. Then damages basically refers to payment in form of money. Okay, damages is remedy available in terms of money consideration. Section 76 Contract Act provides for the party who sustained damage has the right to rescind the contract and is also entitled for compensation. Okay, next is specific performance. Specific performance is said to be granted when the court compels the defaulting party to perform his contract. This remedy is given at the discretion of the court and is governed by Specific Relief Act 1950. So for specific performance, it's actually order made by court for the party who is in default to perform the contract. So that is specific performance order made by court. For injunction also, it's an order made by court to prevent someone from doing something. Okay, both specific performance and injunctions are actually order made by court. And then lastly, quantum merit. It means as much as he has earned. Okay, on breach of contract, the party injured may be entitled to claim for work done and service performed as much that he earned, the amount that he lose lah. Okay.